It's the third week of January 2024. The year feels as if it is moving quite fast,
It is.
quickly.
It is.
Yes, more than our bodies and our minds can manage, but we push ahead. Welcome to Jamaicans for Justice. Let's Start Justice Radio program. My name is Michael Jackson.
And I'm Jade Williams.
All right, so busy week in the political landscape. We were just having a discussion, Jade and I, what were some of the human rights issues that may have arisen last week, because we believed when you look at the news cycle, it was quite active, but it was with political issues and so on. So but some other important things arose that we still feel it is important to mention. So, several weeks ago, you heard us talking about the Domestic Violence Act, and we made note in the media landscape with other media houses and so on, and with public statements that the Minister of Culture and Gender, Oliver Babsy Grange, had tabled a bill which was subsequently approved in the House that sought to increase the penalties for those within the Domestic Violence Act if you breach the protection order. It has now come into effect as at yesterday, Monday, January 22nd. That means that the $10,000 fine has increased to a million.
Yes.
The 6 months terms of imprisonment has now increased to a year.
Yes.
And I think there was another provision about the orders.
Yes, there was a provision that would have changed the reasoning for application. So instead of listing out the reasoning
Yeah.
for application, you would simply apply if you are being harassed generally.
Okay. And the number of persons who could
Who
now
could make an
make the
application?
application.
Yes.
So as we stated in our public statements, we welcome the renewed energy from the government, of course, in making those adjustments. But for Jamaicans for Justice, supported by the Jamaica Council of Churches, we still believe that the government ought to move with alacrity on the comprehensive review of the Domestic Violence Act. Last year, we heard from the minister that a joint select committee would have been convened in January. It's now January 23rd, so we have 7 days left to see if that joint select committee has so been convened. And JFJ, as at January 31 or perhaps February 1, we will be making a public statement if it has not yet been convened, because again, we need to ensure that we hold our elected officials to account. Yeah?
Yes.
The second thing to make mention of quickly is that we have seen where South Africa, with a complete bravery, one could argue, has filed a claim against Israel and the genocidal acts that we have seen emerging against the Palestinians before the International Court of Justice, the ICJ. And we have seen where the Advocates Network, supported by the Jamaica Council of Churches, have called on the government of Jamaica to support South Africa in that claim, because since last year, we have had 24,000 Palestinians killed by Israel, 70% of whom are children. When you look at the bombing, the starvation by denying them food, and then when you see an area is protected, you still go out of your way to again commit these genocidal acts. So I think it's safe to say that we support the call by Advocates Network that the government ought to be speaking more on what is happening rather than that middle ground approach that we see emerging. Because when you have injustice of this nature, it is quite alarming that the United Nations as a body, we are not seeing that type of denouncing that will be needed to say that these international bodies are actually working to the extent that one would want it to. You know, I'm in a group with some human rights advocates, Jade, across several countries, some of whom have indicated to me that, listen, you know, we've lost faith in the system. That is the impact, because a genocide is being committed right before our eyes in 2024.
I have to echo the sentiment. Every time that we talk about the history of human rights in like one of our trainings or something, and we talk about it coming out of the atrocities, the genocide that took place in the 1930s to 1940s,
Yes.
to see that the system that we set up to prevent or to eradicate these kinds of acts has done nothing to stop it is very disheartening. So I can certainly understand
to the point where senior officials have resigned because they believe that these bodies have not been doing and making the public statements necessary that is expected of them. So we call on the Jamaican people to again take account and pay attention to what is happening in the news cycle. Yeah.
Yes. All right. So the next thing that would have been on the news cycle is our major topic for today. So we'll hold off on that until we start our topic, but we'll go straight into our Did You Know / right of the day for today. And it comes from our Appellate Jurisdiction Act, which is that piece of legislation that governs how the Court of Appeal operates in Jamaica. And under Section 13 of that act, it details your right to appeal of any decision made in the Supreme Court to the Court of Appeal. And if you have to have a legal grounds of appeal, or you can appeal on the basis of fact, which is that you are appealing something that the judge decided during the hearing of your case. Now, there are some cases that you will have to get permission from the court in order to seek appeal, and that is called leave to appeal. But we'll talk a lot more about that over the course of our coming episodes, and certainly on our social media if you want to learn more. And then we have our trivia question for today, which asks, in Jamaica, how many judges sit on the Court of Appeal for one case? So if you have an appeals case in the Court of Appeal, how many judges can you expect to hear your case? And you can respond through our social media. You can give us a call at 676-4996, or you can send a message at 2397583.
All right. And the appeal discussion will certainly come up today.
Yes.
But we will leave that. So today we're discussing the topic of legislative trend of mandatory sentencing. And we're going to be joined by Mr. Anthony William, who's an attorney at law from USIM and Williams Company. He's a defense attorney, but within the context of his presence here today, he's representing the Jamaica Bar Association. Specifically, this is Criminal Practice and Procedure Committee.
Yes.
He chairs that committee?
No, he is a member.
Okay. So we certainly look forward to Mr. Williams joining us in short order. But just to get into the discussion, before we read what we have here, the bills that are currently before the House of Parliament, it was tabled last week.
Yes.
In that sitting. And given the implications of that, three bills that are being proposed based on the Joint Select Committee around mandatory minimum, the Childcare and Protection Act, the Criminal Justice Administration Act, and the Offences Against the Persons Act, it was tabled but suspended to be discussed today.
Yes.
And apparently, based on the urging of some members, some clips that Jade has put together for us, they have urged them not to suspend, so we're expecting it to be passed today, which is also one of the concerns we have broadly about the House of Parliament and ease with which bills can be passed via simple majority. But that's subsequent discussions to be had. Yeah? Yes. But excessive mandatory minimum sentences have increased in presence in Jamaica's legislative framework in recent years. And just to put in context, we already have mandatory minimums for serious crimes, rape and murder. But when we say increased and excessive, it means that it is moving from 15 years to 45 and so on. Again, we will highlight that. But in 2022, the Firearms Act was introduced, which saw the removal of judicial discretion. And I have to pause here, Jade, before I continue reading, that the Firearms Act already had mandatory minimums in it. So some of what we had hoped the Firearms Act would have adjusted and dealt with based on the gaps, it's still fraught with problems because the government just increase without looking at the implications. But since the implementation of those mandatory sentences for several firearm-related offences, including a 15-year minimum for possession, we have seen a decline in guilty plea and an anticipated court backlog based on warnings coming from the Chief Justice, Brian Sykes.
Before the recent Firearms Act, there were many pleas, guilty pleas, because offenders usually get between 5 and 10 years. But now, because the mandatory minimum is 15, they're not getting the pleas because people will take a chance, you see. Well, the only incentive which was put in was that they must help to say where they got the gun from, who they got it. You get me? So in other words, the offender can come within the plea negotiation act if they help the crown to solve crime. So, but many, unfortunately, many don't want to be an informer.
That was Minister of Justice Delroy Chuck.
On Tuesday, January 16, 2023, as we would have said, Justice Minister Chuck would have tabled the amendment to the Criminal Justice Administration Childcare and Protection and Offences Against the Person Acts. And these provisions have been anticipated by those persons who would have made submissions to the committee to have further negative effects on our justice administration. Now, the sentences are also disproportionate in JFJ's view. For example, for non-capital murder, a child at the age of 14 years and an adult could both be considered for a life sentence, and if not, they could both be considered for a determinate sentence of 30 years. And the only difference in those sentences would be the period that each would serve before being eligible for parole. Now, even with these punitive provisions, Member of Parliament Robert Montague scoffed at the proposals and made some alarming comments in response.
I believe that the offer from the minister, I just want to get it very clear that it will not be suspended or ended next week. Because I have very, very strong views. Because we cannot ask the taxpayers of Jamaica.
Your suitable comments were sufficiently indicative of your strong views. You will have a chance
to pay for mind them.
You will have a chance for that member. Your mic is on for us to get that clarity.
I apologize, madam.
Yes, you
but
will
we
have.
Must hang them.
No, that was Robert Montague, who thankfully was silenced by the House Speaker, Juliet Holness, during last week's sitting. Now, when we look at the memoranda of objection reasoning in these bills, the government indicates that it is responding to the high crime rates. But as we have noted, that is not enough reasoning and justification to be making such significant changes that will impact the criminal justice administration system in a way that you will have court backlogs. It means, again, that if you are accused of a crime, you can be held in pretrial detention for years before your matter is adjudicated. For those who are affected by crimes, those offenders, if you will, the perpetrators, when you wait years for those matters to be dealt with, it means that witnesses move ahead, gone to other countries and so on, and then the case falls through and you get no justice as a victim of those crimes. Rape victims and so on, it means that when there's court backlog, the dates that you will have to have your matter heard, it is pushed back. So these are far-reaching implications. When we even look at the evidence, as pointed out, you're talking about, 47 children who have been charged with murder over a 5-year period. So why are we making these far-reaching changes with our laws when the evidence doesn't support it? And quite frankly, we have heard from the Minister of Justice himself that the public demands it. But Minister Chuck, as we will be discussing today, we're asking for you to balance again what the implications of these bills will be and how we balance what the public demands versus what is actually needed and be guided by evidence. So we're going to take the break and then we will be joined by Mr. Williams so we can hear Jambar's perspective on these matters of real and grave national importance. Welcome back to Let's Talk Justice. We are discussing the issue of mandatory minimum sentences in Jamaica, the excessive nature of it as being introduced by the government with the Firearms Act last year, and certainly with the proposed bills that we expect to be passed in the House today dealing with those involving murder. We're joined by Mr. Anthony Williams, attorney at law and a member of the Jamaica Bar Association. Good afternoon, Mr. Williams. Mr. Williams?
I think we may have just lost Mr. Williams. May have just lost him.
So while the team tries to get back Mr. Williams on, one of the things, Jade, and I always have to thank you publicly for flagging this, because when the Firearms Act was tabled last year, you kept saying to me, Michael, it's automatic life imprisonment. And I said, Jade, no, you're wrong, because there's no way I could fathom that the House could get together and think it makes sense to have the imposition of life sentence for the possession of an illegal weapon. But for you to use that weapon and hit somebody, hurt somebody, threaten somebody, it was a mandatory term of 15 years with a maximum of 25. So even those incongruencies that we had last year was amended. But what is shocking to me, because we've seen several foul-ups with this particular bill, but what is shocking to me is that rather than fixing the foul-ups, the government, as announced by the Minister of National Security, is suggesting that the Parliament goes back to that imposition of...
Yes.
So, anyway, we now have Mr. Williams?
Yes, we have him.
Hi, Mr. Williams. Good afternoon. Thank you so much.
Good afternoon, yes, and thank you very much for having the Jamaican Bar Association given its opportunity to voice its concern.
Thank you. We appreciate your presence. Before your former president departed office, Mr. Alexander Williams, he was the one who represented Jambar before the Joint Select Committee, noting Jambar's position on the mandatory minimum. So over to you, Mr. Williams, just to start as an opener to indicate what Jambar's general concerns are with the mandatory minimums as we have seen them with the Firearms Act and currently and specifically with the one surrounding murder.
Well, first of all, Jambar is very much appreciative and also have its grave concern about the high level of crime in the country. And therefore, as a result, the Jamaican government have to move swiftly to pass legislation to impose a mandatory minimum. One of the things that Jambar is very concerned about is that the sentences that are set by Parliament are primarily to remove the discretion from judges. Once you impose a mandatory sentence, then it means that judges no longer have that latitude to exercise their discretion. So what it does, it forces them to impose a specific minimum sentence, right, regardless of the circumstances of the particular case. So each case is to be judged on its own facts, on its own merits. And so one 16-year-old or one 14-year-old or a 10-year-old child who has committed the offense of murder, for example, the commission of the offense is certainly different in each case. So it removes the latitude from the learned trial judge who is going to sentence that young offender, right? Now, the Jamaican Bar Association maintains that judicial discretion is an essential feature of the justice system.
Yes.
If we're going to maintain fairness, if we're going to maintain balance, then judicial discretion is an essential feature of the justice system. And so we are saying that the Parliament should not impose these mandatory sentences on the individual, the youngster, because it removes this essential feature. And so essentially it makes Parliament have no regard for judicial discretion. Now, there are some objectives of sentences, which is denunciation,
Yes.
deterrence, the separation of offenders from the society, rehabilitation, and the acknowledgement of and the reparations from harm that they have done. So when you're going to sentence someone, you're sentencing them based on the categories of sentencing, right? Now, the Bar Association would like to also emphasize some principles in relation to trial offender. And we would like to quote from a noted author, D.A. Thomas, in his book, The Principles of Sentencing. And at page 20, he said that youth is one of the most mitigating factors. And the young offender is usually treated less severely than an older person in similar circumstances. There's also a noted Australian author, that is Sir Richard Edney and Mirka Bakaric, in their work, The Australian Sentencing. And this is what they said. They said the authorities disclose that when considered as a mitigating factor, youth will generally be given significant weight. So the younger the offender, is the more it is taken into consideration. In particular, the author continues, it will compel the parsimonious use of criminal sanctions, which do not have the primary aim of rehabilitation. The underlying justification for such a policy position is the idea that the immaturity of youthful offender may lead to such offenders not being able to appreciate the extent and nature of criminality. Now, we are saying that youthfulness is very, very important. Now, there have been cases that the Bar Association has done some extensive research on, and one such case is the Queen versus Sargent, a 1975 case, right? In which the principle of rehabilitation was mentioned, and the court emphasized that a young man does not want prison training. So when you impose mandatory sentencing on youngsters, the court said in that case that the principle of rehabilitation is important. A young man doesn't need mandatory prison training. You know, what he needs is rehabilitation. Now, there are several factors that the court would take into consideration when sentencing anyone, including a minor. And one of the things that the court certainly takes into consideration is the youthfulness, right? And we also would like to refer specifically to a case in the Bahamas. It's called Royal versus the Attorney General. And this was in 2012, where an offender, 17-year-old, he was sentenced to 25 years imprisonment, and that was reduced to 10 years imprisonment. The court suggested that special consideration must be given to the sentencing of a young offender. And the court stated that the rehabilitative aspect of a sentence should be paramount. So it is easier to rehabilitate a young offender than a more senior person, you know, somebody over the 50s, etc. And so this 25-year sentence was reduced to 10 years.
So how would you respond to the submission of the Office of the Director of Public Prosecution, who had indicated that some of the more shocking cases brought before the office were committed by child offenders? And in that regard, the DPP made a recommendation that the mandatory minimum should be limited to children who commit capital offenses. How would you respond to that particular recommendation?
Well, one of the things that we are seeing from the Bar Association is that young people, they are more receptive to changing the way they conduct themselves, and they are able to respond more quickly to intervention. So yes, they may commit some very shocking and gruesome murders, but we do not think that the minimum sentences that they impose should be that high. In fact, the impact of punishment is felt more heavily by young people, in the sense that any sentence will seem to be far longer in comparison with their relative age, right? So we do understand and appreciate that there are shocking murders, there are shocking instances, and some may even shock the entire Jamaica than an offense committed by an older person. But the Bar Association is of the opinion that the minimum sentences that are imposed by the court should be left to the discretion of the learned trial judge, because there are many instances in which a social inquiry report may prove very fruitful and very positive for that individual, although the murder was shocking. And so, again, we are saying in emphasis that the judicial discretion should not be trampled on.
Mr. Williams, while you brought up several examples of case law where persons would have successfully challenged an excessive sentence, I know we have a recent judgment in our history with Tafari Morrison, who went all the way to the Privy Council.
The Privy Council, Yes.
Where they didn't necessarily find in his favor. And I wonder what your opinion is on future actions coming out of these proposals that we're seeing now.
Well, Article 37 of the United Nations Convention on the Rights of the Child certainly came up in the Safari Morrison case. Article 37 of the UNCR really places a ban on children being subjected to torture or other cruel, inhuman, or degrading treatment or punishment, including the death penalty or life imprisonment without the possibility of release. It is very clear to the Bar Association of Jamaica that Jamaica certainly did not abide or did not want to abide by the convention, which is the Article 37. Right? It is to be noted that the Privy Council did not refrain from commenting on the analysis. But as I said, this was highlighted in the Safari Market case, where the board concludes that Jamaica has taken a deliberate decision not to implement the terms of the United Nations Convention on the Rights of the Child.
Mr. Williams, we are up on a break, so I'm going to ask you to hold that thought, and then when we return, we follow up on that discussion, including the fact that children can be sentenced to life imprisonment without the possibility of parole, as currently provided for in the Childcare Protection Act and reaffirmed in this bill that we have before the House to be passed. So we take the break and then we follow up with the discussion.
Welcome back to Let's Talk Justice. We're discussing mandatory sentencing in Jamaica, and we're joined by Mr. Anthony Williams, attorney at law and representative of Jamaica Bar Association. Mr. Williams, just before the break, you were talking to us about the implications of the Tafari Morrison case on future actions, as well as the fact that children can be sentenced to life imprisonment without the possibility of parole.
Yeah. Now, what I want to make clear on behalf of the Jamaican Bar Association is that in the Tafari Morrison case, the Privy Council highlighted at paragraph 21 of that judgment, right, that the decision taken by the Jamaican government appears to be a deliberate decision not to implement the terms of the United Nations Convention on the Rights of the Child. Now, the imposition of mandatory sentences as it relates to children, right, should be used only as a measure of last resort and for the shortest appropriate period, because children are less likely to commit the more egregious offenses than adults. So in 2019, the United Nations Committee, right, in its general comment, clarified the right and stated that mandatory minimum sentences were incompatible, absolutely incompatible with the child justice principle of proportionality. So what we're saying is that there's an international principle of law that speaks about proportionality. And so with this requirement, the detention must be a measure of last resort and for the shortest appropriate period. Again, this is highlighted at paragraph 15 of the Safari Morrison case.
Yes. One of the things, Mr. Williams, we wrote a last effort letter to the Minister of Justice up to this morning, and our policy specialist Jade here beside me, she noted something that was quite alarming in the bill, that the principle of proportionality is not being adhered to, because adult and a child is being treated almost equally when it comes to non-capital murder, and there is not much difference when it even comes to capital murder, save and except for the mandatory minimum for the period to be served before you are eligible for parole. For adults, it's 50, and for a child, it's now 20, save and except for the fact that a judge is not even compelled to impose such period. So Jade, I don't know if you want to clarify for the listeners the proposal.
Yes. So what we would have noticed is that, as Mikhail said, for non-capital murder, and well, for all aspects of murder, the determinate sentences that are allowed are essentially the same. However, the period that the judge can stipulate before it is that you can be considered for parole is less for children than it is for adults.
So for non-capital, it's what? Life imprisonment or 30 years
Yes.
to be served, both adult and child.
Yes. And then for a child to be considered for parole, it is 15 years. For an adult to be considered for parole, it is 20 years.
Yes. So Mr. Williams, the point is that even when Jambar made its representation last year, it was just a broad 20-year mandatory period. We're seeing now where the Joint Select Committee has revisited that proposal, and in our estimation, we think this is far worse than what was proposed before. So I'm not sure if you had an opportunity to read the current bill with what we're saying here, and if you have any position on it.
I didn't get the opportunity to read the current one, but certainly it emphasizes that the procedure for children are to take into account their age. And Jambar is emphasizing the desirability of promoting their rehabilitation. And as I said before, that justice requires fairness.
Yes.
And one aspect of fairness is judicial discretion.
Yes.
It is very critical, absolutely critical.
It's a principle of a
judicial
democracy fully, actually. Before we even get to the principle of the criminal justice system, any democracy must have separation of powers between the three branches of government. So we agree.
Yes. So judicial discretion is very, very important. In fact, Jambar is of the opinion that the continued failure to adopt the key principles from these existing treaties, because Jamaica is one of the signatories to the treaties as it relates to the Convention on Children, which it has ratified, is not only a breach of international law, but it is depriving all children in Jamaica of their legitimate expectation that the rights guaranteed under these international agreements will be enforced and implemented in favor by the government, right? So that is the position of Jambar. And you see...
Yes, go ahead.
When a judge is sentencing an individual, be they a minor, or an adult, or a senior adult, one of the things that the judge takes into consideration is the actual social inquiry report, their antecedents, the victim report, which is now part of the criminal justice sentencing requirement in Jamaica. And so they have an opportunity of hearing what these reports are saying. The community, the police report, which may be very positive of that particular youngster. And they take this into consideration. So we don't want the government to remove or eliminate this very critical aspect of judicial discretion. And as I said, Jamaica is part and parcel of this international agreement.
Yes.
It's an international agreement between Jamaica, and we ought properly to abide by the convention.
Yes, absolutely. One of the things, Mr. Williams, I want us to talk briefly on before we are out of time is the fact that the government is touting, if you will, that they have made provisions, as they did with the Firearms Act, wherein if upon sentencing and the judge imposes that mandatory minimum as they are compelled to, you can apply for a leave of appeal to to have the Court of Appeal look at your matter. And we know that the Court of Appeal may not agree and rule in your favor, and you may have to go to Privy Council. And one of the things I try to impress Jade and I is that even based on the right that we read earlier at the start of the program, you already have a constitutional right to appeal. So what they're suggesting as some sort of safety or safeguard isn't really anything compelling. And in our estimation, and as we said to Minister Chuck, we're almost legislating social inequality in law. Because you understand, Mr. Williams, that if a matter were to go all the way to Privy Council, I'm not sure how many people could afford your services as a defense counsel. So, which is why, we're concerned. So I don't know if from that perspective or generally what you're observing based on the matters that you and your colleagues have before them, within the concerns of the possible leave of appeal as well as guilty pleas and so on.
You see, it makes it very challenging and it ties the hands of the Bar Association as well as defense lawyers, because once the legislation imposes a mandatory minimum, then the judge has no other option but to impose the mandatory minimum. Otherwise, the judge would have acted contrary to the legislation. And so that is why we are saying that when it is left to the judicial discretion of the judge as to the appropriate sentence, every judge, right, is guided and is directed to have a starting point. There must be a starting point. There must be a range of the sentence. So the judge would determine the range to say, well, the sentence would be, say, 20 to 30 years or 30 to 40. And then there's a minimum range. Once you maintain that, because there is a sentencing guideline that is applicable in Jamaica, our judges are using it. They have been case law. And so it would lead to less appeal when you allow the judges to exercise their discretion.
Yes.
And as you rightly said, it is very, very expensive to go to the Privy Council. I don't know if many persons know what is the airfare alone, just to travel to London, not to mention retaining counsel and hotel airfare and the other attendant costs.
Yes.
To travel to London for an appeal.
Mr. Williams, this will be our final question. We mentioned it when the show just started that the Firearms Act passed in and put in place in 2022 already has some of the challenging sentences that we're talking about today. What, if any, effect have you observed in your practice or in the practice of other members of the association that this would have had?
Well, I think Minister Chuck alluded to it, in that once you impose these high minimum sentences, from a government point of view, we understand, because they are trying to cauterize the high level of crime. What we also have to balance is that offenders are not going to put in the guilty pleas as often as possible as they would want. And you're going to have a backlog in the system, because someone is going to say, look here, why should I plead guilty when I'm going to take my chances and have the case tried? Witnesses may not turn up, police may not turn up.
You just wait out the period.
So just wait out the period, So these are some of the challenges. You're going to have a backlog, and so the Office of the Director of Public Prosecution, in terms of caseload, is going to increase significantly.
Yes. All right. Final word from you, Mr. Williams, because Parliament meets today at 2 o'clock.
Yeah. Well, the Bar Association is saying to the government that in relation to the minimum sentences imposed in relation to child offences, that it should really reconsider its position and allow the decision, the judicial decision of the judges to be paramount and to take effect, as they have been doing wonderfully, and allow them to assess and evaluate each case on its own merit to determine the correct sentence for the child.
Very well. Thank you so much. That is Mr. Anthony Williams, representing the Jamaica Bar Association. Thank you, Mr. Williams, and we hope to speak again.
Thanks again.
We take the break, and then Jade and I will close out the topic and discuss some other matters, because Jamaicans for Justice, we made a submission to the Constitutional Reform Committee. So we will talk very briefly on what is to come. Welcome to Let's Start Justice. We just want to close out the discussion that we were having earlier, Jade. with Mr. Anthony Williams from Jamaica Bar Association. And just to indicate to our listeners that since the start of 2024, we have made several public statements urging the government to reconsider what can only be described as a legislative misadventure that they are pursuing. We have seen the evidence on the Firearms Act. Quite frankly, those two mishaps with
misapplication.
Misapplication of the provisions.
Yeah.
Then secondly, between the prosecutors and the courts actually sentencing someone on a bill.
Yeah.
That was quite alarming. So what you find is that these harsh penalties, convoluted legislation, they're being passed without there even being a time period that the criminal justice administrators, which would include the judges, the prosecutors, the defense attorneys, and so on, have an opportunity to really understand what is within it.
Yes.
Then the other thing is that everyone warned, well, let me not say everyone, I think that's maybe a hyperbolic comment, but several people, including JFJ, warned the government, certainly, that the matter of the guilty pleas would be an issue.
Yes.
And they went ahead.
Yeah, I remember in our presentation, we had a brief exchange with the committee chair,
Minister Chuck.
Where there was a period of conflation between the Criminal Justice Administration Act and those plea arrangements versus the Plea Negotiations Act and those plea arrangements. And they do have a very significant difference in that the Plea Negotiations Act, which is unaffected by many of these proposals, requires you to give evidence against whoever else is in the matter with you, against yourself, against other persons, to assist the prosecutor with the case.
It's deliberate, actually. Outside of the committee having that confusion, if you will.
Yes.
It's like the law is forcing you to go and help the prosecution in their matters. And certainly that should be encouraged. But just imagine that you have a child who is under the influence of a gangster. And the witness protection program in Jamaica is weak. It needs strengthening. How can you basically shift people, force them to help the crown when you don't have provisions to protect themselves in terms of their lives and their families? So, these are some of the things. You heard us talking about the court backlog, and we can't help but re-emphasize the importance of recognizing that if it is that there is a backlog and we see the efforts from the Chief Justice and his team in reducing that, if it is that we were to return, and we are already seeing us returning to the possibility of increased court backlogs, it means that your matters, you as victims of crime, you will not have your matter heard because people will just wait it out. Let me wait on the witness to go away. Let me wait on the system itself to lose the documents and the evidence necessary to bring the matter before the court. This is the kind of justice system that needs overhaul before we even start talking about increasing mandatory minimum. And I think my last point personally on this particular issue, Jade, is that we're seeing a particular legislation being pushed through Parliament that is not needed.
Yes.
Based on the issues, because the government can't say to us that the judges are imposing light crimes. You're having a far-reaching legislation where 47 children have been charged with murder over a 5-year period. So why are we pushing it through?
Yes.
Yet still, we have a Domestic Violence Act that have been languishing for 5 years. The Sexual Offences Act, same. Since it was passed in 2009, we have not had any amendments, despite the calls. So rape victims, including men and boys who can't be raped in law, those things have been set aside. But you're pushing through laws that are not needed because the public demands it. And to be fair to the public, you're demanding based on a high crime rate. It is legislators who understand the law, or ought to understand it, and the implications that should know better. So, yeah.
Yes. Thank you for that, Mikhail. I think It is an area that we'll continue to be passionate about because we can see that it will have a detrimental effect, and we've seen it have a detrimental effect in other jurisdictions that have employed similar tactics. So,
and they're moving away from it.
yes, absolutely.
Yeah.
So we hope that our listeners will be tuning in to Parliament in another 8 minutes or so, so we can keep abreast with what is happening and we can be aware if the legislation is passed as is.
And I hope the parliamentary opposition understand their role as guardians of the Constitution, rather than us focusing on election and whether or not we will win favour with the public. That is my caution to the parliamentary opposition as well, because that is your role. And those who support simply based on party affiliation, we're asking you to read this mentality of backbenchers who simply knock the benches and support anything that your political party put forward without a fulsome understanding of the issues. We're saying to you, do better. We must. And with that in mind, last week we submitted our constitutional reform, finally.
Yes.
After months, eh?
Well, it was worth the wait, I'd say.
We'll see. So we are aware that the country is undergoing, well, I hope, that the country is undergoing a constitutional reform process headed by Minister of Legal and Constitutional Affairs, Marlene Malahoo Fort. And we have put forward some proposals to the committee via the Permanent Secretary, Mr. Wayne Robertson. And we have some plans afoot, supported by Jade and Nicholas Richards, our newest recruit, if you will. He's in the studio doing all kind of reels and that kind of excitement. But yeah, so what are some of the plans, Jade?
Yes, so we'll be doing some public education materials, putting out some of our proposals and putting them in brochures, as well as some general understanding of our constitution or set up our governmental processes so that we can participate fulsomely in this. We also plan to do some town halls around the country. We're coming out of Kingston.
It's a justice tour, yeah?
Yeah, we'll do our best. But we'll be doing those town hall sessions focused on constitutional reform, talking about what our options are, talking about the process, getting an idea of how the public is thinking. So we'll look forward to sharing those dates. You can look towards our social media. We'll also be making some graphics and other informational nuggets available in all of our channels, to our Twitter and our Instagram. So keep following, and that update will be coming soon.
Yeah, thank you so much. And just to indicate that some of the matters that we are proposing includes, for example, and let me be very clear, JFJ in principle, we support the constitutional reform process because we support removing the monarchy as our head of state. Given our history, once colonized by the United Kingdom, from a place of pride and dignity, you know, we have to move away with having the monarchy, having that sort of oversight, if you will, on our country's affairs based on the design of our governance structure. So that is something I want to reiterate on behalf of the Board of Jamaicans for Justice. We're going to be explaining to you what our head of state proposed looks like. The non-executive president, how such individual ought to be elected. We have some other proposal focusing on the CCJ, the Caribbean Court of Justice, which we have intimated we already support for us to adopt. We have the National Human Rights Institution as a body that we're saying ought to be established and entrenched in the Constitution, and that body replaces the Office of the Public Defender. We have, broadening the rights?
Yes, we have an expansion of our constitutional rights. We also have a proposal to help with enforcement of those rights outside of our national human
But
rights
yesterday, the conversation that was just being had with the
Yes.
Tafari Morrison case, for example, wherein we sign on to these conventions, but there's absolutely no obligation on the state to transfer or transpose some of these international obligations into domestic law, because we're what we call a dualist country.
Yes.
Right? So I hope you see where some of the constitutional arrangements are so important with the enforcement and respecting of our fundamental rights and freedoms as we so fought for. years ago, and we're going to be trying our utmost to break down the things to you, because we believe that the Constitution must be owned by the citizens of Jamaica. And for you to own that process, it means that there has to be an understanding of what currently exists, and you can see the gaps as you so understand them to be, and then make those demands from your ministry and
representatives.
Yeah.
So we look forward to sharing all of that with you. I would just like to announce our trivia winner before we go. Our trivia question was, how many judges sit on the Court of Appeal for a case? And the correct answer is 3 judges. It could be more, but 3 is what we were looking for. That is the general amount.
That seemed very open door. That looked like some pep question that I look at and say, but it's have multiple answers.
It is not very open. It is only in the special circumstances that it wouldn't be the 3 judges.
Okay, your question didn't demand it. This is not defending the social media users today,
Well, we have a winner. It's Kimmy. We'll reach out to you via DM. Thank you for participating.
Right. So we will see you next week. It may not be our topic, but I know Vanessa has some plans for corporal punishment to be on the agenda next week. So, yeah.
Yeah.
All right. Thanks again for joining us, and we will see you next week. My name is Mikkel Jackson.
And I'm Jade Williams.
Take care.